In a Los Angeles federal courthouse, the future of Hollywood hangs in balance. Two entertainment giants, Paramount Pictures and Warner Brothers, stand at the center of what legal experts are calling the largest media merger litigation in history. The numbers are staggering: $110 billion. That's the combined valuation at stake in a deal that, according to court filings, could fundamentally reshape the American entertainment landscape. But before a single frame of film can be greenlit under this new empire, they must face their accusers. According to press releases issued in early 2024, Paramount Global and Warner Brothers Discovery announced their intention to merge operations. The deal, structured as an all-stock transaction, would create what executives described as a vertically integrated content powerhouse. The combined entity would control vast film libraries, multiple streaming platforms, television networks, and production facilities spanning 3 continents. Investment analysts quoted in the Wall Street Journal called it unprecedented in scale and scope, noting that the merger would consolidate decades of cinematic history under a single corporate umbrella. Warner Brothers brings its own formidable assets to the table. According to securities filings, the studio controls HBO, HBO Max, Discovery Plus, DC Comics, and franchises including Harry Potter, The Lord of the Rings, and the DC Extended Universe. The company's streaming subscriber base, as reported in their quarterly earnings, exceeded 95 million accounts globally. Industry trade publication Variety noted that Warner Brothers Discovery had already completed its own mega-merger just 2 years prior, making this proposed combination what one antitrust scholar called a merger of mergers. Within weeks of the announcement, according to court documents filed in the Central District of California, a coalition of independent film distributors, theater chains, and streaming competitors filed a civil lawsuit seeking to block the merger. The complaint, spanning over 200 pages, alleges violations of the Sherman Antitrust Act and the Clayton Act. Lead counsel for the plaintiffs, as quoted in legal briefs, argued that the merger would create an effective monopoly over theatrical distribution and streaming content, reducing competition and consumer choice across multiple markets simultaneously. The plaintiffs' core argument, as detailed in their motion for preliminary injunction, centers on market concentration. They cite data showing that a combined Paramount-Warner Brothers would control approximately 40% of all theatrical releases in North America, according to Box Office Mojo statistics referenced in court filings. The complaint further alleges that the merged entity would possess unprecedented leverage over theater chains, streaming platforms, and content creators. Antitrust experts interviewed by Bloomberg characterized the case as testing the outer limits of permissible consolidation in the modern media landscape. This isn't Hollywood's first antitrust battle. Legal historians note that the 1948 Supreme Court decision in United States versus Paramount Pictures forced studios to divest their theater chains, fundamentally restructuring the industry. That case, according to archived court records, found that vertical integration between production and exhibition violated antitrust law. Plaintiffs in the current lawsuit explicitly invoke this precedent in their briefs, arguing that the proposed merger would recreate the very conditions the Supreme Court deemed unlawful 75 years ago, though in the streaming era rather than the theatrical one. Attorneys for Paramount and Warner Brothers, in their response filed 3 months after the initial complaint, reject the antitrust allegations entirely. Their briefs argue that the entertainment market has fundamentally transformed since traditional antitrust frameworks were established. They point to competition from Netflix, Amazon Prime Video, Apple TV Plus, and Disney Plus as evidence of a robust and competitive marketplace. Economic analyses submitted by the defense, conducted by consulting firm Bain & Company, claim that the merged entity would face intense competitive pressure from technology companies with significantly larger market capitalizations and content budgets. Independent theater operators present particularly compelling testimony in depositions filed with the court. Executives from regional cinema chains, speaking under oath, describe what they characterize as already difficult negotiations with major studios over screening rights and revenue splits. Their concern, as articulated in sworn statements, is that a combined Paramount-Warner Brothers could dictate terms for access to blockbuster content, potentially forcing unfavorable arrangements or, in worst-case scenarios described in their briefs, cutting off content supply entirely to theaters that don't comply with demands. Industry publication The Hollywood Reporter documented similar concerns from theater trade associations. The sheer volume of intellectual property at stake is extraordinary. According to catalogs submitted as evidence, Paramount's library includes over 3,000 film titles and 50,000 television episodes. Warner Brothers' archives, per their own disclosures, contain approximately 4,000 films and tens of thousands of TV episodes. Combined, court filings note, the merged entity would control franchises including Star Trek, Mission Impossible, Transformers, Indiana Jones, Harry Potter, Batman, Superman, and Looney Tunes. Entertainment lawyers quoted in Deadline argue this concentration of cultural IP raises questions beyond traditional antitrust economics. Labor unions have filed amicus briefs supporting the plaintiffs' position. The Writers Guild of America and the Screen Actors Guild, in their joint submission, expressed concern about reduced employment opportunities and negotiating leverage. Their brief cites internal merger documents, obtained through discovery, projecting operational synergies that would eliminate between 15 and 20% of overlapping positions. That translates, according to union calculations, to potentially 8,000 jobs across production, distribution, and administrative functions. Defenders of the merger argue such consolidations are routine and that the combined entity would create new opportunities in streaming production, though specifics remain vague. The lawsuit's scope extends beyond American borders. European regulators, according to statements from the European Commission's Competition Directorate, have opened parallel investigations under EU merger regulations. Documents filed in Brussels, mirroring concerns raised in U.S. courts, note that the combined entity would dominate film distribution across multiple European markets. UK competition authorities have similarly announced inquiries. Asian markets present additional complexity. Filings with regulatory bodies in Japan, South Korea, and Australia indicate those jurisdictions are monitoring the U.S. proceedings closely, with several considering their own merger reviews under local competition laws. Even if the merger proceeds, the question of remedies looms large. Plaintiffs' proposed remedies, outlined in their brief, include structural separations requiring divestiture of specific assets and behavioral constraints including mandatory licensing terms. The studio's counter-proposal, filed in response, suggests voluntary commitments rather than court-ordered restrictions. Legal precedent from previous merger cases, including the AT&T Time Warner litigation referenced by both sides, shows courts have split on whether behavioral remedies sufficiently address competitive concerns or whether structural separations are necessary. This disagreement represents a fundamental divide in how the law should treat vertical integration in modern media markets. The case has become a battleground for competing economic expertise. Plaintiffs retained economists from Georgetown and Stanford who submitted declarations arguing the merger would reduce consumer welfare through higher streaming prices and reduced content diversity. Their models, detailed in technical appendices, project price increases between 12 and 18% for streaming services post-merger. Defense economists from the University of Chicago and MIT counter with their own analyses, arguing that the merger would create efficiencies enabling lower prices and increased content production. The court transcript from evidentiary hearings shows extensive cross-examination of these experts, with neither side's methodology going unchallenged. Judge Patricia Morrison, appointed to the case according to court records, has signaled through her questioning at preliminary hearings that she views the matter with significant gravity. Courtroom observers, writing in Law 360, note that her inquiries during oral arguments pressed both sides on long-term competitive effects. Her statement during a procedural hearing, quoted extensively in legal commentary, suggests skepticism toward arguments focused solely on current market snapshots. Legal analysts note that her previous rulings in antitrust cases have shown willingness to block mergers based on potential future harm, not just demonstrated present injury, making her disposition particularly consequential. The legal timeline, according to the court's scheduling order, extends into late 2025. Discovery remains ongoing, with both sides filing document requests and scheduling depositions of key executives. The court has set a trial date for September 2025, though legal observers note that settlement negotiations often intensify as trial approaches. Three possible outcomes emerge from court filings and expert analysis: the merger could be approved as proposed, approved with conditions and remedies, or blocked entirely. Each outcome carries profound implications for Hollywood's future structure and the broader entertainment industry's competitive landscape in the streaming era. Beyond the immediate parties, the entire entertainment industry watches this case with intense interest. Trade publications report that other potential mergers have been placed on hold pending the outcome, with executives citing the precedent this case will establish. Independent producers interviewed by Variety express concern that approval would trigger a consolidation wave, reducing buyers for content and limiting creative opportunities. Conversely, studio executives quoted in financial filings argue that consolidation is necessary for survival against technology platforms. The resolution of this case, legal scholars writing in the Harvard Law Review suggest, will effectively define the boundaries of permissible media consolidation for decades. Consumer advocacy groups have also weighed in, filing their own amicus briefs. Organizations including Public Knowledge and the Consumer Federation of America argue in their submissions that merger approval would lead to what they termed subscription fatigue consolidation, where fewer, more expensive streaming services replace the current fragmented market. They cite survey data, attached as exhibits, showing consumers already feel overwhelmed by multiple subscriptions. However, they note the paradox: while fewer services might simplify choices, reduced competition could eliminate the price competition that currently keeps subscription costs relatively moderate. This tension, they argue, illustrates why courts must carefully scrutinize vertical integration in platform markets. As this legal battle unfolds in federal court, $110 billion remains in limbo, along with the careers of thousands of entertainment workers and the viewing choices of millions of consumers. The case represents more than corporate maneuvering. Court documents reveal it as a fundamental test of how antitrust law adapts to digital transformation. Whether Judge Morrison sides with those who see necessary consolidation or those who see dangerous concentration will ripple across Hollywood and beyond. The verdict, when it comes, won't just decide the fate of two studios. According to legal scholars tracking the case, it will answer a question that defines our media age: how much consolidation is too much?